So the thing that I'm going through in my mind at the moment, and this is in some ways a video more for myself than the thousands of people that come to my YouTube page. Probably can count them on one hand. The key thing here is I'm looking at the Bill of Rights 1688, and there's a couple of things that are going through my mind in this process, which I don't necessarily I'm stating the correct answer or not. But the first element is that the third part of the Bill of Rights is that, and the Bill of Rights 1688 basically is something that ensures you get liberties, access to court, have freedom of rights, have a freedom of expression. And we already had one of these, and we've turned around and we changed it in 19... Well, no, we didn't change it. We passed the 1990 Bill of Rights Act, which was largely empowered by the Constitutional Act of 1986, which did not go to referendum, wasn't passed by House majority, so it's actually non-vari, which means literally illegal, but a legal fiction. And that's in fact just what Justice Cook called it. The principles of where the way it was passed, also the fact that it was passed by singularly House majority, I would also challenge comes under the well, I would say it was the same principles that was challenged the Muldoon Superannuation Act in 1975, Fitzgerald versus Robert Muldoon, which demonstrates that the Bill of Rights 1688 is not just some kind of like rough guideline, and that's how it's sort of been largely sold, and how judges are kind of getting away with just, well, not judges actually, they're not the ones at fault here, the politicians are. But the third part of the Act, I'll just carry on again, because the 1986 Constitutional Act then kind of moved on to, later on we got the 2004 Supreme Court Act, which was also a step passed through, not following due process. And this is becoming, Geoffrey Palmer the other day, he's actually made this comment in Power that, like, we've got a problem because Parliament's just going up there and doing whatever it wants. Again, the first part of the Bill of Rights 1688 says no, Parliament doesn't have a right to empower itself. Literally, what Fitzgerald was saying with Robert Muldoon in 1975, more recently tested in the UK, which is also a Westminster-based system, with Boris Johnson when he tried to close down Parliament on himself. And they turned around and said, no. You are a politician. You don't have the power to shut down Parliament. But the third part is basically that no Catholic king shall sit on the throne, or basically, but it's deeper than that. And this is the part that's, when I read into it from politically and academic-based texts, what it makes clear to me is that it's not actually aimed directly, even though it says the Catholics, I think of the word in itself, what it's actually talking about is ecclesiastical power, military tribunals, or in other words, any form of power by a foreign power cannot be allowed to exceed the structural and natural hierarchy which places the courts at the top. And again, it's matched in New Zealand under the Imperial Acts by Article 29 of the Treaty of the Magna Carta. Now, just a little point there. A lot of people like to go out and quote the Magna Carta. And that's a different, I would say no. The only thing part of Magna Carta that actually applies to New Zealand, in my interpretation of it to date, is Article 29. And in fact, it's also pretty much true in the UK, where the actual Magna Carta has been changed, like virtually every single part of it's been changed, bar Article 29, which is the right to trial, what we sometimes misleadingly call habeas corpus. Now, the wording of that basically says it also that you cannot have your rights removed, and that again works lockstep with the Bill of Rights 1688 or 1689. Some people do, but those things both in the way that they lockstep each other, and also the wording of them, especially with Article 29. It's the one thing that our Parliament hasn't been able to undo, and they're doing all these sorts of other things to try and get around it. And there's a thing at the moment called the Declaration of, I think, called inconsistency, which is a really dangerous bit of legislation, which is saying that anytime government oversteps the Parliament, they no longer have to go to the judges. They can just go out there and a panel will pick three people, and they are the yes men that will do what they're told. And that, again, is, I would say, breaches the Bill of Rights 1688. It's a funny bit of actual work because, I have actually spoken to Warren Pike, who's the president of the Barristers Society. Barristers Society? Yeah, he's a barrister. And again, he's, lawyers have been lawyers. Oh, I can't talk to you unless you take me under the blah, blah, blah. And I'm like, well, look, I just want to know how this bloody all looks actually right about this publicly. But, that's the way, and he's the only one that's actually, he recognises it. Well, he's not the only one, but he's made reference to it during the COVID situation. But it comes to a question of how you go to enact it. And pretty much what I've concluded, and this is, I will admit I'm on thin ice, but this is my interpretation, is that it's not something you actually have to do anything about. It's just a case of if you feel that it's been breached, you then turn around and you go to court, and that's your defence. And basically, it's a pretty good defence. And really, like as Pike said, a robust citizenry, if they were to turn around and do this in numbers, the court would have a problem on its hands, because basically, we're right, and B, you mentioned how many times that would take in the process. It would quickly mesh up the court to the point where they'd actually have to address this issue in a far more serious way than they've done to date. Generally speaking, what happens is, in this case, there's the case of what her name is, Kate something or other, and she claims to be the rightful descendant to the Chatham Islands, but she just talks a lot of waffle and a lot of nonsense, and she seems to be basically on the grift, and that's the problem with a lot of the sovereignty movement that's come around, is that they know a little enough to be dangerous, but not enough to really know what they're talking about, and they actually are, endangering of diluting people understanding that common law is a very serious thing. But you've got to know your judo, and that goes back to the application of Bill of Rights 1688. But getting back to my point is that the issue becomes that all these international treaties that we are signing up for, which say, in the event you don't do this, then we're going to take you to our tribunal, investment state settlement dispute clauses they have in the case of the TPA, which means that you've got a classical order that now has power above the courts. And I would actually say, and this also goes with the issue about the global climate achievements. And again, to put my credentials on my card, I do believe in global warming. I, however, side with James Lovelock, which is basically saying that as New Zealand is not the chief contributor, and us kind of like signing up to laws where no one else actually is kind of like just really dumb for our economy. And the reality is, we could be actually practicing and applying much better models of sustainability that will have more real measures on protecting the planet than joining up to basically a carbon Ponzi scheme, which is decided by people who talk to us about global warming while they fly into $10,000 room night hotels on Learjets. I'm afraid to say, unfortunately, the whole notion of climate change in terms of Kyoto has been absolutely hijacked and politicalised and weaponised, unfortunately. But it doesn't change the situation. We're getting back to my original point that all these international treaties that we've been, slyly lockstepped in, all part of the World Economic Forum and the World Health Organization. No politician in New Zealand has a right to get us signed up to any of these things, because they go against the laws of our own bloody land. Unfortunately, 1980 they also banned the Treason Act, which is about the same time they got rid of the 1986 Constitutional Act. That's probably just coincidence, but you sometimes do go, actually, I wonder if they knew something we weren't. At final, of course, the quiver of this is that you've got, you do have this issue of Parliament passing more and more laws against due process and thinking that it's more empowered. And the more it happens, the more it becomes entrenched. So you need into a process of acquiescence. People think this is a normal thing, so it becomes the new normality. But, what we have this whole situation is also this other dilemma we've got, which is even with if we ignore the fact that the Supreme Court's illegal itself, and that the Privy Council, we were somehow to be able to activate the power of the Privy Council at the moment. The issue we've got there is that every time one of the judges have died, who are actually people that are actually very, very, these particular judges are very educated in constitutional law and all these international law, and they used to go in London, and they would have all these different judges that were 42 judges, Supreme Court judges in New Zealand. They're all linked by blood or by marriage. And you expect you're going to get a fair share hearing in that particular, which is the reason why the Privy Council, in my opinion, was the superior and the least dangerous in terms of danger to democracy than the current Supreme Court Act, which is kind of like, basically it's a kangaroo court. And it's, anyway, moving back, the Privy Council is actually, when judges die, they're actually replaced by MPs. And so you've got MPs, and some of them are sitting. Winston Peters, for example, last time I checked, he was still a member of the Privy Council. But we have a sitting MP who's also a Privy Council. So he's a legislative and he's the judiciary. Well, that's a no-no, because literally they swear two different oaths, and you cannot have two different mistresses. But again, we don't have any real serious international, we don't have these real serious arguments about this. And again, even when I go looking into the issue about the international, how does international law operate with Bill of Rights 1688, there is no conversation about it, which doesn't mean that it's not legitimate. It just means that nobody in the status quo wants to talk about it. The Privy Council, of course, aside from having people that are both Bill of Rights, politicians, and then on the Privy Council, so they're also lawyers. So again, I always have a problem with lawyers being allowed to be MPs full stop, because again, I see this as a conflict of interest. And again, I don't think, that's one of the things I'd really like to dig into, find out, when did this start happening, and really, should they actually even be allowed to be You know, literally, you can only swear aloof to one mistress. But going back to the Privy Council, the other issue we've got with Privy Council is that Great Grey Lanimer, I think, is one example, and there are probably about over half to 60% of the politicians that are now replacing the judges on the Privy Council, the mothball Privy Council, because they couldn't get rid of it because those pre-existing legislations, and you know they could work around it, but they can't actually go against the law. They're trying, but they are very trying. But ultimately, the Privy Council is stacked with people who are also members of a globalist lobby group, and it's across the board. You've got members of ACT parties, you've got members of the Green Party, you've got members of the National, you've got members of the Labour Party, and this group is called Parliamentarians for Global Action. Look it up. Go and also have a look at what it's formally known as, which is the Parliamentarians for the New World Order. I shit you not, that was the name. I had a very interesting conversation with Mike Moore about this. I rang him up probably in the early 1990s. This is about the time of Codex Alimentis, which was the attempts by corporations to basically create themselves a new kingdom where they were the new kings and queens and had monopoly over everything for all food and water, which in fact water was classified as food and medicine under the Codex Alimentis. And we fought this, and we fought against the world without borders, or world without walls, that Mike Moore, as a hard zealot neoliberal, not a communist, but a hardcore pro-corporatist, chairman of the World Trade Organization, tried to push through in 1995, and it got thrown back in his face. And that they even made a movie with Woody Harrelson in it called The Battle for Seattle about it. But it got repackaged about the same time that after Mike Moore had been ambassador to the United States of America, and then he became the minister, UN envoy for global migration, and he repackaged the world without walls that had been rejected and seen through as basically free power to the corporate groups, and they repackaged it as the global migration. And again, it all comes back to this whole issue of, through the UN, which is the UN, as we've seen for the Russian war, it's a UN that's no longer the United Nations. It's the United of the Five Eyes powers that are representing the corporate interests, and all these things that they're trying to do under the pretext of being, protecting the planet or protecting us against poverty and diversity or wanting diversity. When you strip them down, they don't do any of those things at all, and they are largely driven instead by corporate entities. And it's quite interesting when you go to the United Nations, like in New York, and you turn around, you kind of, and you get the whole thing about the fact that the United Nations is based on the New York, operates for the New York conventions, and so do things like the Trans-Pacific Partnership Agreement. And this was a very post-war, very new legislation, post-war, 1952, and that legislation basically redefined the definitions of human rights, not based on the Westminster system, which you will find mostly within America, because again, America's own constitution is largely based on English-based systems, Westminster, Bill of Rights 1688, Magna Carta, the Abroth Accords, etc., etc., etc. But the exception is New York, because that was originally a Dutch colony, and it was the New Amsterdam. And again, you turn around New York and you see these, beautiful Dutch buildings on the when you look up the hill. And the state law definition of human rights means it's under Dutch customary and corporate law or commercial law. So the definition of human rights is Father Arrejo, and I do not know how to pronounce his last name, so I won't. But he's a Catholic Jesuit, and he's an expert in international law. And he argues, he says, the 1952 convention was a trick because it's actually turning the clock back and putting the dog leash, or taking the dog leash off, which is the Union Jack, the Westminster Parliament, that says, monarchs can't just do what they want, the first part of the Bill of Rights, 1688, and it's removing that, and it now has a new definition of human rights, which basically means that the rights you have are the rights that the captain or the agent of the corporation gives you, and he can give it and he can take it away. And that's the danger about the 99 Bill of Rights, which we never actually entrenched, or never said, well, these acts are protected and entrenched law, which can't be changed. We just said, we'll do that later. But all it did was actually suck us into under international law as Bill of Rights as interpreted by the United Nations, which according to the 1952 New York Convention, or I sometimes say New York Accord, basically changed the rights that you don't have any, and you turn the clock back. And that's all these people are running around trying to tell you that the Union Jack is, it represents the Queen and the corgis. They don't know their arse from their elbow, and it's actually been done quite deliberately. And that's another story altogether. But that's where we have it. Like they would, we have this thing of Bill of Rights where you go trying to go and work out, wait a minute, how can this be in the Commonwealth actually be taking our orders or from these international orders that basically centralise the power, so they're run by largely corporations. So basically, instead of actually protecting the planet, it becomes we just get to make all the money and keep all of it. And the great thing about their economy, according to their system, is that number one, and you're wondering where they're going to run the customers, it doesn't matter, because the more the world they run the world, the more they get in deeper in asset, and the more assets they themselves control, the more those assets are actually worth. And number two, they can do models of scarcity. If they're running out of people that can afford their products, doesn't matter, as long as somebody can afford their product. That's all. That's their customer base. And if you're not part of the customer base, we don't care. Fourth industrial revolution's come about. We no longer need to be nice to the middle class because we've got all these AI technology that can just say, screw you, we don't need you. We're just going to worry about our gated billionaire cabinets, communities, and we'll live paradise while the rest of the world slowly gets festering into a poisonous, toxic, horrible, heated up mess. And that's the same thing again. All the people say, oh no, the global warming doesn't exist, blah, 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 because blah, 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 blah. Yeah, okay, guys, whatever. But reality is, you don't have to be a rocket scientist to work out that all these corporations, the way they are actually dictating the planet in terms of the pollutions they release into the planet and into humanity, making, Jamie Oliver's food revolution, where it's like they couldn't literally stop give them better, healthier food for the kids in the States because the corporate lobby power had become so powerful, and it actually protected their rights to actually poison their own citizens. And that's all because of the Roscoe-Conklin Act, which an act basically came out at the end of the slavery in the United States of the USA after the Civil War, and giving the slaves their freedom, rightfully so. But Roscoe-Conklin then argued, so well, actually, if chattels actually have rights, and then so can corporations, and he made up a whole bunch of precedents which nobody in Congress or Senate ever bothered to fact check, and they're all lies, but they passed it anyway. And so 200 years later, because of a bunch of lies, the entire Western world is dominated by this fact that these corporations, which are not actual living entities, they're just an organic machine that wants more, to consume more, to have it all, has the same rights as you and I, but there is no transparency and there's no accountability. And of course, things like the Bill of Rights 1688, the English statute, Magna Carta Article 29, should be giving us these rights, accountability and transparency, but unfortunately, because of Parliament has come to think that it actually can now empower itself, those checks and balances are being disregarded, and we are constantly getting ourselves deeper and deeper into these international treaties, which I would deeply question their legal legitimacy. Anyway, something to think about.